Now, for those of you who are returning, obviously this is a webinar which we've been running a webinar series for the past couple of months now. Obviously, just before Christmas, it was very much focused on how to go about fundraising. So we're working with Social Gamma. They were able to successfully fundraise over 8 million through social media, which is absolutely fantastic. We then kind of worked with Uncapped, different form of fundraising. So looking at the debt side, so in terms of revenue-based financing, and then obviously working with CrowdQ, which was very much looking at how you can utilize the crowd to go and fundraise. Whereas kind of the second part of this series is very much focused on putting in good structures. Obviously today is very much focused around the legal aspects of that. But yeah, today is really a fantastic opportunity for you to really kind of learn, ask questions. I think given the size or the number of people on the webinar today, we can make it interactive where possible. So if you do have questions kind of throughout, please feel free to drop them in the chat box below, and we'll be more than happy to pick that up. But yeah, I'm more than happy to kind of pass you over to our new partners in Avery Law. I think you'll see today from the webinar, they certainly offer a very personalized approach in terms of how they work with their clients, mainly focused on pre-seed, seed, and Series A. So hopefully that's very applicable for all of you on the call today. But yeah, Dave and Jessica, over to you.
Thank you very much, Matthew. Yeah, I mean, firstly, thank you so much to obviously Matthew and Claim Capital for asking us to host this webinar. Obviously introduce my colleague Jessica, sat with me. We're both going to run you through essentially, you know, probably the fundamental legal considerations as part of your sort of pre and post fundraise. And as Matthew said, please, if there's anything that when we're going through this you can think of questions, please jot them down, throw them in the Q&As, and we'll be happy to answer them at the end. So I thought just very briefly just introduce our firm. Matthew, thanks for the introduction. Just to add on to that, so we are a fully regulated law firm, but a boutique firm in the sense that we specialize well within the growth tech sector. So a lot of our clients, probably 90% of our clients are scaling or startup tech companies all the way through to exit. A lot of them either have either listed company sort of injections of capital, or they've exited wholly to private equity, or have gone above. So we mainly, because of that technology focus, what we've tried to do differently as a law firm is we've tried to essentially adopt and utilize as much technology as possible in provision of our legal services. So we do consider ourselves quite client focused in the sense that we get technology, we adopt it, and that sort of provides us what we think is a very client-centric service. So as I said, we assist startups all the way through to scaling, and we try to avoid any legal jargon. We're quite commercial. We've seen lots of transactions, so we are very commercial in our approach. Yes, we are lawyers, but we understand that actually people don't want to spend all of their fundraising budget on lawyers. So it's just sort of understanding where you actually should be spending money. And we can talk about that as we go. So in terms of the sort of talk today, I thought it'd be good to talk about the particular types of fundraising that we see and that we're advising on in the market. Then we'll move on to how you will want to go about preparing for a fundraise, and then we'll talk about the actual process. And as part of that section, we're also going to talk about what happens post fundraise. So sort of just after the raise, some of the legal considerations going forwards. So in terms of the fundraising, I mean, there's really three elements. So a lot of people will always, actually a lot of people ask us, how should I fundraise? And traditionally there's three types. And we'll concentrate mainly on the equity side for the purposes of this webinar. It is the most common form of fundraise in the market, especially in the UK. And that sort of leads on to the third point about investor relief. So normally a fundraise is dictated somewhat by your investors and the composition of investors. So if there are, tax relief schemes such as SEIS and EIS available in the UK, for example, then you would traditionally go down an equity route of fundraising as opposed to a debt fundraising. Debt can traditionally be used as a form of bridge financing, and we'll just touch upon those very, very briefly. So as I mentioned, equity is the most common form of fundraising in the market, especially in the UK. I think we just talk quickly about the composition of an equity round, and that normally dictates the way it will move forward. You probably will have heard of various crowd raising platforms, Crowdcube, Seeders, the like. You've got angel syndicates and networks and other platforms to help you find investors. So really the dictation of the round is really your composition. So are you speaking to angels? Are you on a platform? Or are you speaking to more traditional institutions like funds and venture capital trusts, or US funds, for example? And then you've got the sort of mechanics of the round. Is it one completion at a fixed valuation, or is it a rolling close over a period of time? Where there's not particularly one lead orchestrating the raise. Or then fourth on the list, you've got your ASAs, which are your advanced subscription agreements. You probably would have heard of them in the States, known as SAFE, or they're also called eFast here, which are a form of essentially, capital, so equity, but no shares are actually issued. So it can be a very cost-efficient way of getting cash into a bank account very quickly. And really they're used where you don't have a fixed valuation. So it allows you a little bit of flexibility to bring on people. And they normally get a discount for taking that risk and coming in early, and then they will get their shares on the priced financing round. So just very, very briefly about debt. So the two types of main debt funding structures are your convertible loans. You may have heard sort of during the COVID pandemic about the Future Fund loan. That was a form of traditional convertible loan. There are various mechanics similar to what I discussed about the ASA in terms of conversion and floors and caps in terms of values. And then you've got your more traditional debt, which is a traditional finance facility, i.e. a loan, which will obviously have a maturity repayment date, will accrue interest, probably will be secured. In early stage companies, mainly tech companies, the security will be in the form of a debenture. So there will be a fixed and floating charge over most of the company's assets, but really they want the control over the intellectual property if you're unable to repay. And sometimes because of the risk for an institution providing finance, they will want some form of warrant, which is an equity kicker, like a sweetener for the deal, and that will normally be a certain percentage of the company for either a fixed amount or at a discount on a future fundraise. Various mechanics around that. We're not going to go into detail on that on this webinar. Just moving on to the preparation aspect for a fundraise. We always talk about it because actually a lot of clients come to us having used Google as their preferred lawyer. And I suppose we say it because there are some horror stories around it. But Google is not your friend necessarily when it comes to finding the right lawyer. We try to encourage people with quite sort of cost efficient fee proposals and structures, and the way we help you get proper legal advice, but please, try to avoid Google lawyer. And we always say, try and get a good lawyer early, build up that connection. What we do is we try and offer a lot of guidance pre-fundraise about what you should do, just so that you're sort of prepped, and you look more, respectable in front of investors come fundraise time. And that what we call is your insurance policy. Just like you would go out and get directors' officers liability insurance, getting a good lawyer on board early is your legal insurance policy. So the next thing we always talk about pre-fundraise is considering a data room. A lot of early stage companies will use Dropbox or Google Drives. That's great for an early stage company, may not necessarily be great later on, but just having a base where you have all of your legal documents sort of kept up to date in order can save you a lot of time come fundraise when a fund traditionally would send a due diligence questionnaire and you want to give them access. So just being prepared and having documents, as soon as you get them signed, put them into some form of data room. It's also a great filing system. It's just good to get into that habit. And then thinking about your share capital structure, your cap table. A lot of people will come to us with a few shares in issue, or they may have promised loads of other people shares in the background, early service providers. Making sure things are documented early in terms of who owns what in a company can go a long way with your investors, because there's always a lot of reorganization to do pre-fundraise. Whether it's a subdivision of shares for liquidity, just actually transferring shares around between founders in its simplest form, just to get to where you need to get to. So always getting a good lawyer on board who knows what they're doing can help you. I think it's probably important to talk about the types of investors. Finding the right investor for your fundraise. So, in terms of where you are and what you're looking for, in terms of whether you go to an angel syndicate or a platform, how many investors do you want on your cap table post completion? So traditionally, if you think about a crowd-cube fundraise, you might end up with 60, 70 small minority shareholders in your cap table, which can be sort of logistically and administratively quite difficult later on. So you might want to consider obviously a syndicate of more high net worth individuals who would put more cash into your business. So obviously less shareholders. A lot of people in the market say raise as much money as possible in as little time as possible from as few people as possible. And that's sort of true. It really sort of holds value in that sense. Watch out for rogue introducers. There's a lot of people who will, say they will find your investors for X% success fee for a fundraise. A lot of those introducers are reputable and actually really well respected. And a lot of them are actually authorized by the Financial Conduct Authority. So you're sort of protected. Now, introducing in itself, and I won't go into details, introducing itself is not actually a regulated activity, but arranging an investment is. So just be really careful if someone says they'll find you investors. Just, I suppose we always advise people to go with someone who's authorized, because at least you have that, what we call consumer protection, so that if things go wrong, and also reputationally, it just works well. And then obviously thinking about NDAs, people are normally comfortable with signing NDAs, but a lot of institutional investors just don't see the purpose of it, because reputationally, they're like, you're coming to us, why should we sign an NDA? We're quite respected in the market. So don't be put off if an institutional investor refuses to sign an NDA. But do be concerned if you're speaking to sort of more high net worth individuals, or perhaps they're not reputationally known in the market and they refuse to sign an NDA, because that can cause horror stories. You've got sort of so-called investors trying to find information out about the companies. They want to get into that Google Drive data room as soon as possible and essentially steal your ideas. So just be really careful and just know your investor, do some research. So I might just let Jessica just move on to the next part.
Yeah, so once you've found the investor, then the next stage is obviously moving into the documentation around the fundraise and how everything will work. Typically, you'll start with the term sheet. And as David's been mentioning, it's really important to have a lawyer get on board early who can help manage you through this process. I think we find that some people have not gotten the lawyer on board at the term sheet stage because they think it's very commercial and it'll be fine. But there's quite a lot of legal terms that if you don't have a lawyer on board who can advise you at the beginning, it may be harder for you to negotiate out of it later. So it's good to have someone on board who can look through this with you. Some of the key things, I guess, from a commercial sense to just negotiate at the term sheet is who's paying for the investor's costs. typically the company will pay those fees. So we usually try and suggest that there is a cap on that fee, so you're not paying all of the investors' costs, because if it blows out, then most of your investment will go towards paying for their fees, and then you've also got your own lawyers' fees to think of as well. And also, if there's more than one investor that you need to fill the round, making sure that there's no restriction on that, so that you are free to speak to other investors and you're not tied in to that one lead, or they don't have to approve that person. Maybe there's certain things around that which are quite important. Usually around this stage, the investor will send these initial due diligence questionnaires, and that's when they might start asking to see some of your documents as well. So there'll be due diligence around the company itself, but also of the founders of the business. So they might start asking you some more personal questions as well. So as part of this due diligence process, it's just important to understand what to actually expect from it. We always recommend being very transparent with your investors. At the end of the day, if you're looking for a strategic partner to help you with growing your company, it's quite important that you build a good relationship with them from the outset. So covering things up is not always going to be the best way to put that best foot forward. And making sure that you have the intellectual property foundations set up. So usually when you start, as the founder, you might own all of the IP personally, making sure you start transferring that across to the company so that the company actually owns that intellectual property is really important. Seeing if you have all of the commercial terms in place, if you work with suppliers, or there's key contracts that you use throughout your business, making sure that you've got those there and ready to share. If applicable as well, trademarks. If you need to protect the brand name or logos. This is something as well that if you have a lawyer who is a specialist in the area, they can help you with running what's called the clearance searches to see if there's any other trademarks that are already existing, so that you're not infringing on those, or someone already has one. You might need to look at rebranding. It will save you costs down the line if you have someone who knows what they're doing. So that's also important. And then I guess another couple of things is working out your privacy and data registrations. If you control or process information of your clients, that's also important. And if you've got a team, making sure that you've got your employment agreements in place and there's IP assignment provisions from them to the company for any information that they create and IP that they create. So once the term sheet is done, then you start moving into what we call the long form documents. So on the screen here are the main body of documents where we kind of do a lot of the heavy lifting and try and take the burden off you from sitting and reading through 60-page documents. But it's split into kind of 3 different categories. So the main documents is what we call the SSA, which is the subscription and shareholders agreement. It's also could be split up between a separate subscription agreement or an investment agreement, and then a separate shareholders agreement. And then you have your articles, and then a disclosure, which we'll go through in a bit more detail.
But just to add quickly, it's just worth just mentioning that these are the documents you'll see on an equity fundraise. So obviously not going into any sort of debt documents.
I think the key thing to flag here is just the difference between the SSA and the articles. So the SSA is really the agreement in the contract relating to the investment. And then the shareholders agreement side of it is the relationship between the shareholders and the company. And then the articles is the document that will continue going on, post fundraise, and really governs the internal affairs of the company. Between the company and the shareholders itself. And then we have service contracts. So if you don't have any service contracts in place as the founder, you might be asked to enter into some of those that the investor is happy with, because they obviously want to make sure that there's certain restrictions in place on you. And then any necessary IP assignments, as I said before, making sure that any IP that you may have created before is transferred to the company. And then the ancillaries is mainly the corporate governance side of things. So your board resolutions, shareholder resolutions to essentially approve the transaction. So that's what those cover. And so I'll go into those in a bit more detail. So
yeah, sorry, just before we move on to we'll talk a little bit about some of the main provisions, but just going back to the ancillaries. So in terms of the resolutions, just something sort of commercially, which I always recommend to founders is to, especially if you have existing investors or existing, non-founder shareholders in the company, it's really important to get them on board early in supporting the fundraise process. Just thinking about thresholds in terms of number of shares held that you need to get to, for example, to adopt new articles. You've got a 75%, what's called a special resolution. So just making sure you're lobbying enough people to support the fundraise early on, and just letting people know, quite transparently what's going on. So, because what we've seen sometimes is founders don't let people know, and then literally 3 days or 4 days before the fundraise, they're expecting people to sign 60-page shareholders agreement. So it's about keeping people in the loop of what's going. It's an exciting time to actually share that with existing investors, because in theory their shareholding value is growing. So it's just keeping everyone on board. And we'll obviously talk about the disclosure letter later. I know we didn't talk about it now, but we'll go into it later.
So the SSA, the Subscription Shareholders Agreement, covers these things on the screen. So we'll touch on these in very high level detail for you. So the subscriptions and the completion is really how much is the investor paying and how many shares they're getting back for that. And then what are any of the completion requirements? What needs to happen before you can close around, get the money in your bank and continue running the business. So there might be some conditions around that. Warranties and limitations is one of the key focuses of the whole process in terms of the legal side. And this is where the disclosure letter comes into play. So essentially the warranties are promises that you are giving, and it's not always just the company providing these warranties. As a founder, you may be required to stand behind some of these statements as well, which is essentially the investor, making sure that you're putting some skin in the game, as we like to call it. And they're essentially promises around the state of the affairs of the company. So to the extent that any of these things aren't true, then we prepare what we call the disclosure letter. So some of the things that you might be, promising against is the share capital is accurate in the cap table. The intellectual property is fully owned by the company. So if that's not the case, then you prepare what we call the specific disclosure against that statement, and that gives you the added layer of protection. And then the limitations is really putting some protection in place for you so that in the event that an investor does want to bring a warranty claim, which we find is very, very rare, but in the event that does happen, it's putting some financial thresholds and some time constraints onto how the investor will be able to actually bring that claim against you and the company. And then moving on to the information rights and investor consent. So the information rights is really what information will you be providing to the investor going forward? If you've prepared a budget, then you may be required to continually share that with the investor. Sometimes a fund may have specific information rights that they require in order to satisfy their requirements. So don't be surprised if those crop up.
Yeah, and also just to add that, because certain platforms, so if you're on a platform like Cedars, for example, they also have their own platform requirements. So you are required at certain intervals to log into the platform and provide certain information, just to be aware.
Yeah. And then the investor consents are specific matters where going forward you might be required to get the consent from the investor. Say, for example, you're looking to raise again, or you're looking to issue more shares or adopt a share option plan or changes to certain things in the company, you may be required to seek the consent of the investor first. It may be, if it's just a lead investor, it may just be them, or it could be a group, what we call like an investor majority, where you need to get maybe over 50% of a certain group of investors or 75%. And it's also important to note that some of these things will crop up at the term sheet stage. So that's why it's important to have the lawyer who can, you know, look at these things for you and advise you from the beginning. The founder covenants, restrictions, IP, this is quite similar to what you find in your employment contract, service contracts. The founder covenants is really you're promising to do certain things and stand by those going forward. You're essentially promising that to the company and also the investors and other shareholders. And then the restrictions is, you know, typical restraints of trade, but it's not uncommon for a founder to have, I guess, more restrictions given their position in the company. And then the IP is making sure, again, that the IP is assigned to the company if it's owned by you or anything that you create going forward. And then the option pool is really if you're looking to incentivize any service providers or employees with equity in the business, then this is where you can carve out and allocate, say, 10% of your issued capital so that you can then start incentivizing them with shares going on. It's good to have this in place. If you haven't already set up an option pool, it's good to carve it out so it's already agreed. Everyone knows that in the future you'll be reserving that 10%, so you don't have to go back and get the approval later on.
Yeah, and just to add on to the option pool, because we actually get a lot of founders who don't quite understand what it means to say you've created an option pool. There's various stages of an option pool, but literally all it means in the first instance is just the authority from your shareholders to issue shares out of this pool reserved for future hires. So it's a bit like a unicorn in the sense that it doesn't exist until such time as options have been granted out of it. So it sits on your cap table on a fully diluted basis so that shareholders can essentially see their worst case dilution, but it doesn't actually exist. And I've seen founders actually issue shares into like the name of the company, which can't happen, as an option pool. So just you know, obviously there's things you can and can't do, and actually it's not as complex as it sounds. The more complex bit is actually whether you're going down an EMI route, and you know, whether you need to go to HMRC, get valuations agreed, and you know, the terms of the scheme and things like that.
And then the articles is the other long form document. So the first thing that you know usually is covered off is around the share capital and what classes of shares that you have. Investors, we find, you know, it's not uncommon for them to ask for a preference share class, which means that they kind of stand in priority above just your ordinary shares, which maybe the founders own. That preference might be over any payment of dividends, or in terms of an exit, their liquidation preference on that. So they might get their whole kind of preference amount back before anyone else is paid out on an exit. So that's what to look out for there. Sometimes there may be anti-dilution rights as well. So this essentially means that if the company is issuing more shares to new investors, the investors are protected from dilution by essentially being allowed to be topped up without really having to pay for the same amount these new investors are paying for. So they kind of maintain their shareholding percentage.
And just to add to that, so that would only commonly be in the case of what we call a down round. So if you conduct a fundraise at a certain valuation, but then the company doesn't do so well post fundraise, and you conduct another fundraise at a lower valuation, that's when an investor's anti-dilution right would kick in. It basically avoids dilution on a down round. If they are seeking anti-dilution rights without a down round, then push back heavily.
Yeah.
Because then they're just getting free shares.
Yeah. And then leaver provisions is quite important from a founder perspective. It's not uncommon for an investor to want to essentially make sure that you're incentivized to stay. So the leaver provisions would essentially mean that if you do walk away from the company in a myriad of different circumstances, then your shares would be subject to these provisions, and essentially the company has the opportunity to claw them back in certain circumstances. So if you did something bad to the company, if you walked away and set up a competing business the next day, or you conducted fraud, well, then the company probably doesn't want you holding on to such a large proportion of the shares. So that's when those shares would come back. And usually if it's a bad leaver event, your shares are transferred at nil value essentially. So that's also something that crops up in the term sheet stage as well. And something that is also good to think about is how much of your shares should be subject to those provisions. Should it be 100% of your shares, or will the investor recognise that you've already been working a lot in the company to set it up, so only maybe 50% of your shares would be subject to that, so you're not starting to lose all of your shares. And then share transfers is really just covering off things when you might be forced to transfer your shares, how you actually transfer your shares, if there are any preemption rights, which essentially means they have to be offered to the other shareholders before you transfer them to a third party. So there's some restrictions there. And then we move on to drag, tag, and co-sale. So drag along is essentially a majority shareholder protection, which allows, say, 65% of the shareholders to force the minority shareholders to sell their shares if the majority wants to sell to a third party. So you're not held up by the minority and you're not blocked by that transaction. And then tag is really the reverse. So tag is the minority protection. If someone's going to come in and take control of the company, they might require that that third party buys their shares as well, because they may not want to be a minority shareholder under that different control. And then co-sale is typically something that maybe just an investor would ask for, and it might just be over a sale of a founder's shares. So for example, if you're a founder, you want to sell some of your shares, the co-sale right kicks in to allow the investor to sell some of their shares or the same proportion that you're selling as well on the same terms. Board composition and entrenched rights is quite an important one to think about, especially if you are appointing an investor director. Making sure that you still retain some control at such an early level as well, and the investor director isn't coming in and going to be able to throw you out essentially is quite important. You ideally want to make sure that most of the decisions are made at a board level, but that you still have that control. So if there's a couple of founders, making sure that that there's still enough room in that board to get things done without the investor taking that control. And then, I think also as well, just thinking about whether the investor's director right should be attached to any shareholding. So they may be required to pay to essentially keep that seat. If they want that board seat, they may be required to keep, say, 10% of their shareholding. If it dips below 5, well, you may not want them to be able to hold that seat. You may want to give it to a new investor down the line.
Yeah, and then in addition to the sort of board seat, it might be that if they dip below that threshold, there's sort of compromise with having just an observer seat where they can sort of come to meetings or get the information, but they don't actually have a say in what happens. We can briefly touch on this. We've obviously touched briefly on the service contract, but I think probably one thing, just if you have existing service contracts, don't be alarmed if speaking to an institution, if they ask to see a copy or propose for you to enter into a new one. It's not uncommon, especially if you've used like a template employment contract service, for example, that it wouldn't be adequate for an investor on a fundraise scenario. So there will typically be an element of they need to see your service contract, they might need to amend it, or they'll suggest a new one. So there's always that element on a fundraise. Obviously, we talked about the IP assignment briefly. We'll always talk about it because for growth tech companies, it's one of the most fundamental assets of company. But I have seen fundraisers almost be held up where key developers early stage have not signed any paperwork around the ownership of IP. So it's always really important if you're speaking to developers, even at idea stage, make sure you have, even in its simplest form, an IP assignment. And even if it's template, obviously I wouldn't recommend it, but even but something in writing is better than nothing in writing at that stage. So yeah, all your contracts as developers. And then, yeah, obviously your option plans, as part of the fundraise process, we talked about the option pool. It might be that you get investors during the fundraise process, try to dictate the terms on which any option plan should be implemented. Of course, we try to push back heavily for the board to have more autonomy over that, but there are sort of typical, sort of acceleration consent requirements, for example. So if there were an early exit, but someone wasn't perhaps fully vested under their option plan, then the investor might not want them to be fully accelerated on that exit unless they agree otherwise. But actually the argument is, well, if it's an exit only plan, that is the incentivization. It shouldn't matter where the exit is. So there's a lot of considerations even during a fundraise process. If you're talking to institutions, if you're talking to angels, families, friends, it's not something that would ever come up, and the board would be able to implement what they want. So let's actually talk physically about what happens during a fundraise process, because we've talked a lot about the legal documents, but it's obviously important to talk about what we as lawyers do on behalf of the company. So we've got this sort of transaction management, and obviously founders can handle that themselves, but we normally recommend as part of the process that we not necessarily handhold you, that you can focus on running your business, because a lot of founders will spend weeks, months, sometimes sadly a year or two raising funds without running their business. So obviously when it comes to the negotiation, normally we would act as the sort of, I have a good word for it, but I'm not going to say on this webinar, but your sponge, in the sense that in terms of the horrible negotiations, just let the lawyers take your emotion out of the process. We're there to absorb all the the rubbish that comes back from the other side. We're there to help you and actually advise you on, and especially when it comes to email communication and agreeing things as part of the negotiation. It's really important generally not to fire off emails to the other side without having sort of spoken to a lawyer or something, because sometimes actually things in emails can amount to an agreement to certain provisions or points, and they can come back to bite in the long form documents. So it's really important that it's sort of gone through the right stream. Once all that negotiation has happened and the back and forth, you've got the execution stage, and that might just be as simple as signing the document. Whether it's DocuSign or whether it's a wetting physical signing, which some institutions still do, believe it or not. So be prepared for that. One thing just quickly about this is the English law deed, which is one of my common pain points of the English legal system. Sometimes you'll see a shareholders agreement signed as a deed, and it can be very useful, for example, on a drag-along right where you need a power of attorney to drag minorities. That needs to be signed as a deed. It's really important that things are witnessed correctly. But actually sometimes shareholders agreements are not signed as a deed. So just understanding these basic concepts on why, and if someone's saying, well, we don't need it to be signed as a deed, just having a lawyer next to you just to guide you through that process can be really helpful, because otherwise you could have a pitfall a lot later on, well after the fundraise. And then obviously completion, so once documents signed, you've satisfied all the conditions, everyone's ready, then completion can occur, money can be transferred to the bank accounts of the company, and the shares can be issued. So then you've got your completion formalities and all your filings. One thing that's really important to liaise with lawyers on or EIS advisors on is, are there any SEIS, EIS implications in terms of share issue process and completion process? Because HMRC has set very strict rules around when, for example, if you're doing a dual SEIS, EIS round, how you cannot accept any, this one example, how you cannot accept EIS funds before SEIS funds, for example. So you've got to control the process, and that's where the lawyers can really help control the process, so telling people when to fund, etc., and actually physically issuing shares and filing things at company's house. So just be very careful of that, because even though you might have had advanced assurance, you can disqualify yourself very quickly. And then, yeah, let's just talk a little bit about, once you've got the cash in the bank, what happens next. Traditionally, I think we may have touched upon it on the SSA, there might be some, what we call, coming out of due diligence, the investor may sort of put on some post-completion undertakings. So things that you will have to do, requests of the founders, the company to do post-completion. Typically at early stage, we see this being sort of data impact assessments and data policy reviews and or putting proper employment contracts in place, whatever it may be. That's the compliance aspect. What do you need to do to actually comply with the terms of your investment agreement? And what we're doing at Avery Law to help clients is actually create playbooks. So rather than you having to look back at a 50, 60 page document, whether it's both the SSA investment agreement articles, whatever it might be, service contracts, will create very sort of, in their very simple form, it's essentially a table, providing you with very simple to read information about what you need to do to comply with the fundraising documents. And that can go into, you can take that and put it into some sort of internal management, whether it's Slack, whatever people use, they can adopt it and put it in as an internal playbook so that people can understand it. And then obviously you've got to start preparing for your next fundraise, sadly, because most fundraisers are for a finite period of time. They have a burn rate, and you've got to measure that burn rate, and you've got to be prepared. So actually, if you're speaking to institutions, obviously if they have a board seat, it's always good to keep liaising on that, discussing when and how and why you might need funds. So just be conscious that it's literally a continuing process, sadly. It's not a fundraise once, stop. If you're lucky to be in that position, then fantastic. And then I think just quickly touching upon sort of company secretarial, which we call COSEC, and your sort of corporate governance issues. So having someone to take all the boring admin off your hands. We offer a fantastic product, which is a subscription-based service where we'll become your formal company secretary and handle all the administrative parts for you, so you can run your business. And also, but more than that, it's more about investor communications. Good corporate governance. Preparing board packs, just keeping everyone informed on the process, and just knowing what to do and when to do it. So, I think that's probably it. We've got this 1:45, so we'll probably stop there. And I've just thrown up some QR codes if you'd like to connect to both of us on LinkedIn. We're very happy to sort of offer sort of guidance, as and when, and we're always on the other end of a phone call. We invest a lot of time into our clients' pre-engagement, because we do see people all the way through that life cycle to exit. So it's a long-term relationship for us. So feel free to connect with us. That'd be great. And I think that leaves us to answer any questions. So thank you again.
No, thanks very much, David and Jessica. That was really, really insightful. I think obviously when it comes to legals, obviously sometimes for companies it can be quite a daunting exercise. I know there's clearly plenty to consider. Obviously a lot of it was relatively high level, but I think it just gives you an insight into all the different aspects that you certainly need to be thinking about when, whether it's even from pre-seed, as you mentioned, rolling in from pre-seed to seed to Series A, the different types of investors that are involved. So no, that's it's been really, really insightful for myself. Obviously, if anyone has any questions, please feel free to throw them in the chat. I was just going to quickly ask from my side, to try and bring it all to life, I guess, a little bit. Have you got any scenarios? You obviously mentioned about Google Law, people not just kind of trying to do it themselves. Have you got any real life examples when people have come to you and said, David, Jessica, we've tried to have a go at this ourselves and something's caught us out, or there's been a disagreement between investors and the founders? It'd be good to kind of see a bit of a scenario in that sense.
Yeah, sure. So, I probably won't mention particular names,
mention their
of course,
names.
and you know, I'm not here to sort of say any bad things about any other, you know, firms or platforms out there, for example. But you know, there are a lot of sort of template-based investment or fundraising platforms that build legals, and some of which are great, but some of which can cause problems down the line. I think traditionally, one of the things I see quite common is, you know, if you don't use a lawyer and you use one of these sort of template provisions where you build your own contracts, you know, there are, especially on a fundraise, especially if you're doing like an angel or friends and family round, you know, there's almost too many warranties given away. And there's also too many investor majority consent matters. And the investor majority is normally then given to, obviously on that fundraise, a group of angels or friends and family, which when you think about it, they probably don't want, and also can become, you know, very burdensome on the company making, you know, important decisions going forward. It's very different to giving an institution consent matters, but generally you try to avoid giving, you know, consent matters to angels, because I've seen it. You get angels who think they know it all, and they literally can pester you constantly for information, and obviously you don't want that to happen. So I think that's probably the most common thing we see when people use, you know, sort of these other services out there.
Sure. And obviously, I mean, yeah, it kind of goes back to your point about using a personalized service. That way, you know, if you do have any problems, you can just pick up the phone, you can speak to someone, you're not dealing with a platform. So we've had a question from Matt. So he said, what are some common scams in terms of how investors may stack things against you, i.e. strip you of your equity later? How do you combat these issues? Yeah, how do you combat these issues?
Yeah, so I think Jessica actually touched on this. So I suppose aside from, especially in the terms of stripping of equity, so I have actually seen this, sadly, where you give too many board seats away, so that you as a founding team, or even if you're a one founder team, actually that's probably a good point, try to have a co-founder. That's genuinely a really good tip, because it all comes down to who controls the board actually when these sort of internal coups happen. Because when it comes to the lever provisions, it's normally not the investor making the decision, it's actually the board making the decision. So if the investor or a group of investors control the board, then that's when you can be stripped of your equity. And the only thing you can do then is bring a civil claim in the commercial courts, which is incredibly expensive. So it's essentially up to you then to bring a claim to say why you should not have been deemed a lever. So it becomes incredibly hard. But if you have more people on the board, and that's why it's actually a good thing to have some non-execs on the board that can also essentially vote in your favor. So you get more people to lobby to protect you. So I think that's probably quite crucial.
Okay, so certainly one to look out for. Matt also asked, are the slides going to be emailed to us? I'm assuming David and Jessica would be happy to share those. So we can share those after the call. That's absolutely fine. So Amelia's come in with a question. Can you clarify the legal processes and difference between execution and completion phase of the fundraise?
Yeah. So sorry, actually, this is probably one of those legal jargon words that we've thrown around without really thinking about. It's so execution is literally just what I would say is signing of a document, but making sure that signing is legal and valid. So making sure it's been done properly, and that's execution. And sometimes there's certain very boring formalities around. I touched on it briefly. The signing of a deed, for example, and how it might need to be delivered under English law. I'm not going to bore you with the reasons for it, but making sure you get that right will give you a valid legal document, so that obviously you're protected going forwards. That's simply what we mean about execution. And then completion of the fundraise is the physical act of money transfers and issuing of shares in consideration for those money transfers.
All right. And I guess from my side, I think a lot of the people on the call today, they're probably predominantly looking at pre-seed and seed, and they'll be kind of taking a look at angel investment platforms, whether that's kind of Angel's Den or Angel's Investment Network. I guess, have you got any tips for the guys here today in terms of questions that they should be asking to the types of angels or high net worths on these platforms to kind of sift out who could be good ones to go after, who wouldn't be good ones to go after?
Yeah, definitely. So sort of two things coming to mind quite quickly. One is, does that platform bring on its beneficiary investors via a nominee structure? That's really helpful to avoid you having hundreds of minority shareholders on your cap table, and then you're just communicating with one nominee on future shareholders resolutions, for example. So that's a really good question to ask. Some do, some don't, so watch out for that. And then the second one I was thinking before I lost my train of thought was ticket sizes. So in terms of ticket size, what's the average ticket size? Because sometimes you don't want lots of investors who are just going to put £5 in, for example. Unless that's the route you're going down. But typically, trying to understand the ticket size that these angels might invest is quite useful.
Okay. All right. No, fantastic. Well, look, I think that's
just to add to that.
Sorry, go on.
I suppose it might be worth, because obviously some platforms, I'm thinking of Cedars because we work with them a lot, is they have their own actual requirements. So they'll do a legal review of your existing documents and they'll send requirements. So it's worth actually asking, is there any requirements of the syndicate or the platform in terms of, because sometimes they're regulated, they need to look after their beneficiary investors. It's good to find that out early on. And one thing I would just quickly say is, don't just accept them at face value. Speak to a lawyer, for example, because we know exactly, like, for example, what Cedars can, push back on. We know exactly what we can get away with because we've done hundreds.
Okay, no, perfect. Thanks for that. But David, Jessica, thanks very much for today. That was really, really insightful.
Thank you, everyone.
Thanks, everyone.
Have a good day.
Take care. Cheers.